McIntyre. In this case, each party had 15 minutes to argue. I understand the state has waived, so just for you, so there'll be no rebuttal time today for your argument, just your full 15 minutes. You know the argument will be recorded. When you come up, please stay behind the podium. Please make sure you speak loud enough so we can hear you. Please don't move around. We're visually recording you, and if you move around, we'll lose you at that point in time. You should not use the name of any child, minor, or victim in this case. Use initials or something to that effect rather than the name of a child, minor, or victim if you have that need in your argument today. Beyond that, we read your brief and ready to proceed whenever you are.
Okay, thank you, Your Honor, and may it please the court. My name is Stephen Hanadell. I represent the appellant Leroy McIntyre Jr., although in this case he's known as Leroy L. McIntyre. This is a very simple issue that we're seeking in this particular appeal, is that we saw a non-proton on the verdict entry that was filed on September 9, 1991. That is not to be confused with the sentencing entry that was also filed on that same day, but we're talking about the verdict entry that memorialized the events of the trial, and that entry is highly inaccurate. And it's just been, while we focused on other issues all throughout this case in my fight to have him exonerated, this is one of those things where it's one of those little pesky things where somehow it always seems to be an undercurrent to what we perceive as affecting the outcomes and prior adjudications. And there just comes a point in time where there just needs to be accuracy in the record. And the Criminal Rule 36 in the case law cited in the brief makes it clear that the corrections can be done anytime for a non-proton. There is no time limit to this. There is no res judicata. This is simply seeking a correction. We're not looking to, this is not changing the adjudication of the case. This is simply taking what occurred in open court, as per the transcript, and making sure that it's accurately reflected in the journal entry. And that did not happen.
Counsel, were the clerical errors that Mr. McIntyre once resolved now, were they already resolved in the February 3rd, 2016 order?
No, they were not. And that's another source of frustration in this case, because after we won the mandamus in the Supreme Court in December 2015, I had filed motions before my legal judge Tedosio into asking him to say, hey, while we got the opportunity to get this fixed, let's get this all fixed, and get this all corrected before, because since there was no final appealable order yet, that we got an opportunity to get this all fixed and corrected and save a lot of headache later. But I was blown off and ignored, and there was no hearing conducted. I was hoping for one, and so he just cranked out the order, and he basically regurgitated what the inaccurate verdict entry said. So the inaccuracies you see in the September 9th, 1991 entry were regurgitated in the February 3rd, 2016 entry as part of the final order. And so this is why now we're looking back, is like, let's just get this September 9th, 1991 verdict entry corrected. That's all we're looking for right now. We're not looking for any, there's no Trojan horse or anything like that we're seeking at this point. It's just, this is simply, we just want an accurate record, because it just, like I said, the inaccuracy of this record has just long been a problem in this case, and I think it has had, if we take a bigger picture look at the case, it probably has had an unfortunate impact on the way something that turned out, and I think there comes a point where accuracy matters, and that's why even in the case law that I cited was State versus Taylor, State versus Mitchell. I mean, Taylor dealt with in a House Supreme Court case in 1997 where the guy sought a correction 20 years later. State versus Mitchell in the 11th District, where the guy sought a correction 25 years later. And in the Mitchell case, his case had been on appeal multiple times. And the 11th District said, despite the prior litigation history, he's still entitled to the correction. He's still entitled to an accurate record as to what occurred in court.
This is a clerical but not substantive correction.
Correct. That's all we're seeking. In this particular appeal, we're just seeking a clerical correction. You can look at the transcript, you can see what occurred in the trial, and the fact that he was with the prior aggravated felony specification, that was not heard by the jury.
But how did that affect his substantial rights?
when you say substantial rights,
If you,
what?
if
Yeah.
Mr. McIntyre classifies the alleged errors in the journal entry as clerical, how, you know, what is the argument regarding how non-substantive clerical errors in that 1991 interlocutory journal entry affects his substantial rights?
I don't know what the outcome of that is. All I know that we just want the clerical errors corrected, and depending on the outcome of this, you know, we'll take a look at whether can anything be done or not done, we don't know. And right now, I'm just taking things one step at a time. I'm not, you know, I'm not looking to put the cart before the horse or anything. We just want this corrected. And as far as whether that means anything or not, I don't know. And so, right now, that's not what we're arguing, it's not what's before the court. All that's before the court is simply correcting that verdict entry, the September 9th, 1991 verdict entry, to accurately reflect what took place in the trial per the transcript. And it's, like I said, it's been a long source of frustration all throughout this case, and just of having, it gets tiring after a while when, you know, when I'm trying to explain, you know, the history of the case to this court or that court, and have to say, oh, by the way, that entry is not true, because this is what really happened, and it just, there comes a point, you know, it makes things a lot easier to where if we just had an accurate entry, we could just refer to that, and rather than trying to go through the long explanation of, oh, by the way, that, you know, you can't trust that entry, that's not correct, because, you know, the entries do have a presumption of correctness, you know, when people look at a court docket and a court record, which is all the more important as to why Mr. McIntyre is entitled to that accuracy, because who's going to go, when somebody looks up a case and they look at the entries, they're going to presume that they're correct. Nobody's going to go further and look at the transcript and check on that, and fact check that. It's just not what most people are going to do.
Let me ask you, I just was a little confused. Was this a motion that was filed by counsel, or was this a pro se motion?
I filed it.
And
So,
what was the date of that one?
what's that?
What was the date?
Oh,
Or even the year, because obviously
It was a little
the
while back.
docket is very long.
it was, because it sat there for a while.
That's what I thought too.
And then the appeal was stayed for a while we were pending the outcome of litigation and another appeal, because had we been successful in that appeal, that would have mooted this matter. I filed a motion on September 14, 2020, and it was, the trial court denied it on February 10, 2023. But I believe there was an issue with the way that the trial court initially denied it, and then this court said it was not a final appealable order, so the trial court had to correct its denial.
Not pro tem.
So that way, so we're back here, and then even then, the appeal was stayed for a while pending the outcome of another appeal Mr. McIntyre had. So we're finally here, because like I said, had we been successful in the other appeal, it would have mooted the outcome of this case as well. So, but at this point, we just want this thing to be accurate, and so there's been many. This case has been just a cornucopia of errors, and just an economy of errors all the way around. And so, we're just sometimes when we're trying to, you know, figure out, well, what do we focus on, and what's strategy and stuff. It's just you can only do so much at a time sometimes, and you know, as far as, and so at this point, we just want, this is one thing that we know we can get done. We can get it corrected, and you know, whether it has any impact later, we'll see. But you know, he has, you know, ultimately we're not giving up. We're not giving up. You know, when you look at anybody who's reading the transcript of this trial, he was convicted on ambushed eyewitness testimony that his lawyer objected to during the trial, and also, you know, another eyewitness testimony. There's no medical, scientific, physical evidence that ever connected him to the crime, you know, as far as like DNA or anything like that. And you know, these crimes were committed in darkness, and so and Mr. McIntyre has maintained from day one that he didn't do this, and you know, and he's going to continue to. And so, to that end, I mean, I admire his endurance, and that he's just not giving up because he didn't do it. And so, even though this correction in of itself is not going to, you know, suddenly open the prison doors or anything like that for him, or in any way get the case overturned or anything like that, but it's just at least one thing to have is just an accurate record. Because even when it comes to persuading other, you know, whether this court in the future about something else, or persuading another court about whatever other issue that may come up, the accuracy of that record matters.
Okay, counsel, I just wanted to make double check. So if the court, you're saying that the actual verdict entry by the court saying that jury was, you know, deliberating, came back with a verdict on such and such date at these counts, that's what you're talking about?
Correct, on
Okay.
September 9th, 91 entry.
Right, and so I guess then the actual sentencing entry, which would say after being found guilty by a jury on these counts, so that would have to be amended too, that would have to be corrected too, because I assume, and I'm not remembering correctly, probably, or accurately from all the other appeals, but it's my understanding all that was in error as well.
It would have to be,
So if we-
but that's not before the court right now.
No, I know.
So I
but-
just, we just decided we're not, I don't wanna just put the cart before the horse on things. I just want, we just get this verdict entry corrected. We'll see how the court rules on it. And then, you know, whether we, you know, if it means we can do something about the errors in other documents, then so be it. And whether that ends up, you know, impacting anything, I don't know. And because there's just, I can't predict how the court's gonna rule on other matters in the future. And also, as far as whether we decide to pursue those matters, I can just tell you, even when it comes to, you know, arguing, let's say if we're going to the House Supreme Court or going to federal court in a habeas corpus action, it's in those kinds of places where the accuracy of this record matters. And so, this is just one small step, but as far as other steps we may have to take, you know, I'm not ruling those out whatsoever. But I just don't want to sit here and say, oh, we're for sure going to do this or do that on anything. This has a wider impact, I think, more than just errors in other documents. It's also, I think, just perception of the case too. And that's why I think the policy and the case law, you know, when you look at the State versus Taylor, State versus Mitchell, when those guys, you know, were 20-some years long after the fact, they were still entitled to those corrections. And so the courts have held very consistently that no matter how long time ago it is, you know, the defendant is entitled to an accurate record. So and that's what we're seeking here. That's all I have.
Thank you.
And thank you.
On behalf of the court, thank you for your presentation. The court will take the matter under confinement and issue a decision in due course. When that decision is